Good afternoon, everybody. It's a couple of minutes after 5, so we're running a tad bit late, but I am going to start the session, and I'm sure it will trickle in as we go along. We have 3 presenters this afternoon, and I will be introducing them one by one as their turn to speak arises. Welcome to Track B, Plenary. Law, Human Rights, and Gender Issues in the Caribbean HIV Response. I'm pleased to see a number of you here as we build on a dynamic opening ceremony. This plenary will set the tone for a number of sessions to come and highlight the goals and impacts of this conference for the next couple of days. As was mentioned by the Prime Minister of the Bahamas, many strides have been made in a number of areas here in the Bahamas, and elsewhere too. But we have a long way to go. But we are a resilient people in the Caribbean, and we can also overcome the impact of HIV if we set our minds and hearts to it. We must have the political will and humanitarian drive to reach our goals. Just reflect on the fabulous presentation of Ms. Cheryl Lee Ralph, creator of Divinely Inspired, Victoriously Aware Foundation, or DIVA. I Sometimes Cry, depicting the character Miss Calypso from last night. Today I am sure that our presenters will give some of us food for thought and inspire others, or both. I was asked to relay some administrative announcements, but I have seen that in the meantime they are passing these across and over onto the sessions. But I just wanted to stress a couple of them again, and these will be that particularly your earphones and stuff, because they are running low on the earbuds. You've been asked to please walk with the ones that you have from now on to your other sessions particularly. Thank you. All right. Also, please remember that photography, videography, and audio taping of the audience members during the sessions are prohibited. And I would like to once again thank all of you for adherence and continued adherence to the conference principles and codes of conduct. Without further ado, please allow me to introduce our first presenter. Professor Rosemarie Bell Antoine is an attorney who holds the chair of Professor of Labor Law and Offshore Financial Law at the University of the West Indies and a commissioner of the Inter-American Commission on Human Rights. She is an Oxford and Cambridge scholar with a doctorate from Oxford University, an LLM from Cambridge, and a diploma in international human rights from the International Institute of Human Rights, Strasbourg. Antoine is an award-winning author who has published 8 books and numerous articles. She served as lead consultant to virtually all Caribbean governments, the UK, Venezuela, US, and Canada, and to several international organizations, producing far-reaching policy documents on diverse developmental issues such as non-discrimination, constitutional and public service reform, HIV, juvenile justice, mutual legal assistance, gender equality, labor, free movement, financial law, health, rights issues in law enforcement, and anti-corruption. She drafted various legislation such as on labor codes, HIV, health, non-discrimination, and anti-trafficking, and trained the judiciary. Please help me welcome Ms. Rosemarie Antoine.
Good evening, everyone. Okay. I have been asked to speak on the challenges and prospects in promoting a human rights approach in the Commonwealth Caribbean. So quite a specific topic, and indeed there are very bright prospects, I would say, but also considerable challenges which need to be considered in relation to human rights. I think there's a growing realization that one of the obstacles to an effective counterattack to HIV in the region is the lack of an effective legal infrastructure, which can then provide the impetus for meaningful change. And I suggest that law is a direct and effective instrument of social change and an efficient tool for addressing many of the problems associated with HIV, in particular in relation to discrimination, which not only violate the dignity and rights of persons living with HIV, but also perpetuate the underground nature of HIV. And that, of course, in turn hinders effective treatment. However, while we can say there's some consensus that we need an appropriate legislative environment, there's a lot of discord as to what form, or what's the appropriate form of the legislative agenda. And we know that the human rights approach to HIV has been put forward, but we recognize that some aspects of that approach is still rather controversial in the region. So we need to outline a legislative policy that is both sensitive and effective, which would outlaw discriminatory practices and be able to create new rights which are necessary to protect the society. And I think that policy needs to serve as an educational tool and provide really an environment to create more egalitarian norms in the Commonwealth Caribbean. And I'm speaking specifically to the Commonwealth Caribbean, the common law tradition, and my colleague will be speaking to you about the civil law tradition, Spanish-speaking and French-speaking Caribbean, where it may be quite different. There is, I think, a lot of confusion as to what is a human rights approach, hence the need for this discussion. What exactly do we mean when we talk about human rights in the context of HIV? I think we need to be able to dispel some of the myths around the subject and also to try to offer some concrete proposals for enlarging what is really the umbrella of rights that should attach to HIV. In my view, human rights can be seen to be both a restrictive concept and at the same time a liberating concept. And we need to understand the limitations. Ultimately, the goal is to outline these challenges within the human rights agenda and be able to plan more effectively with that better understanding of the human rights agenda. So what is the content of human rights of which I speak? I think there are two dimensions to the term. On the one hand, human rights, as we understand it, is a very legalistic, juristic concept, which in our system is really confined to the constitutional mores that we have in our jurisdictions, because simply our bills of rights are located in the Constitution. And that juristic concept, of course, could extend in certain well-defined circumstances to the international sphere, to international human rights, for instance. But on the other hand, human rights is a populist concept, which the average individual embraces as an entitlement, whether we acknowledge that formally in a jurisprudential sense or not. And I think that dimension of the subject is very important to our discussion and to persons living with HIV, because people sense that they are entitled to certain rights, and rightly so. But the sad truth is that although human rights seems an obvious route to obtaining just treatment in the context of HIV, from a law point of view or a legalistic point of view, the human rights approach or the human rights that we have in the Caribbean is actually very deficient, and it fails to offer real justice to persons living with HIV. And that is because our constitutions from which our human rights flow are narrow, and I think often narrow-minded law instruments. They are, in fact, silent on important aspects of our rights expectations, or worse, they often import the most discriminatory and harmful attitudes of the society. Because our constitutions are often mere passive reflections of our societies, of ourselves. So if we are a discriminatory society, then the constitutions without more will merely cement discrimination. And you might wonder if this is too harsh a statement. But consider for a moment that freedom from discrimination is not adequately protected under our constitutions because of very myopic interpretations of the anti-discriminatory clause that we do have in the constitutions. And that clause, case law has interpreted that to mean that you must have had an intention to discriminate, or that you must have had bad faith in terms of discrimination. And that burden is so high to be able to prove that it has effectively aborted our jurisprudence on discrimination. But there are some exciting prospects because quite recently, the Trinidad courts have been challenging that narrow view of our constitutions, trying to reverse those interpretations of what could constitute discrimination. Consider too that sexual orientation is not only not mentioned at all as a ground of anti-discrimination in our Bills of Rights, but that in ordinary legislation, it has been specifically excluded on the grounds that sodomy is unlawful. And we've had discussions in this conference about that already. And the argument that those unjust laws are expressly saved by the Constitution. And that, in fact, that interpretation has also been given by some of our highest courts. Reflect, too, on the fact that despite us knowing that the gender dimensions in HIV are important to understanding of the disease, both from a scientific point of view and in relation to hidden or subtle forms of discrimination, sex is still absent as a ground of anti-discrimination in many constitutions in the region. And that means, therefore, you could not bring a suit on the grounds of discrimination on the basis of sex or gender. Similarly, there is no right to health in our Bills of Rights. And the Constitution specifically permit the state to treat non-nationals differently. And that, of course, will have implications for our migrant populations who are living with HIV. And clearly, nowhere in the Constitution you would find any mention at all of HIV. So those are the kinds of deficiencies about which I speak. So I think it is somewhat short-sighted to speak glibly about human rights without really understanding the limitations of the concept. And so we have to be able to comprehend that problem before we can confront it and then address it. So I've been somewhat cautious about the human rights approach because of that. Today, how I view it is that we have to, yes, utilize human rights, but it's not a panacea to our problems. I think what we need to do is to be able to revolutionize the way in which we view our constitutional instruments so that we can have a more just, a more relevant, a more people-centered human rights agenda that will suit the needs of HIV issue and other problems that we face. So what we need to do, therefore, is to reimagine, if you like, our constitutional and human rights mores and norms. And that is a challenge that we face essentially. But I do think it presents some exciting prospects, although it's not a simple task. So we can rewire or reimagine those constitutions to serve us in better ways. And we must therefore be able to reject some of the more complacent interpretations of our constitutions and challenge a constitution to be more dynamic, more responsive to current, more enlightened philosophies. So I believe in human rights, of course. I believe in human rights passionately for every individual. But we must and we have to deviate from the more orthodox or traditional human rights model. And in fact, simply talking about human rights in a vacuum, I think gives us a false sense of security about our constitutions, instead of inviting us to think critically about them. That is the challenge. So while there are rights which are fundamental, which are inalienable, which can be derived from reason, and why human rights as a concept itself does not fail us, human rights instruments can fail us and often do fail us because they're not necessarily reflective of those fundamental rights. And this is not necessarily the case in other jurisdictions. So the human rights approach might fit neatly in other countries, in Canada and the EU and so on, where those constitutions have been more liberally interpreted and where those constitutions are supplemented by other statutes which are based or grounded in human rights, where, for example, there are equality or rights commissions, bodies which supervise those constitutions, and where you have societies which you have high degree of litigation, litigious societies where they test laws and where they stretch the content of laws and pursue remedies very actively. But this is not the case as yet in our region. So constitutions are not perfect instruments, and the assumption, I think, that rights are inherently neutral, that rights are even universal, and that if simply focusing on rights, we are going to move away from the limitations of morality and religion, which often fuel some of these inequities. That, I think, is a fundamentally flawed assumption, because these rights are based on underlying moral precepts which are not necessarily grounded in our own social environments. So part of the challenge, clearly, is the need to educate our societies about the appropriate parameters of human rights. I think, too, that ultimately, the way we have approached the human rights agenda has been somewhat insular. It really has lacked the kind of breadth and scope to address some of the issues at hand. So that, for instance, we need to be able to expand how we view human rights. Some of the things we need to look at would be who are the appropriate subjects of those rights. And that's an important question, especially when we begin to think about vulnerable groups, which is, as you know, a very important consideration in the HIV phenomenon. So how do these groups fit into our construct of human rights? And part of the problem with the human rights approach in our region is that it has been interpreted as outlining rights only for some and not for all. So what we really have are exclusive human rights instruments, when I think they were meant to be or should be inclusive, so that we have excluded persons and groups who really, they should be legitimate beneficiaries of human rights. And in a sense, our own lobbies, HIV lobby, has fallen into that same trap. So we have different groups saying, well, we want rights for this group and that group. And by so doing, in a curious way, we have gone along with this assumption that rights are to be detailed or listed in the human rights agenda. And so in fact, if you're not specifically mentioned in a constitution or bills of rights, for instance, if it is silent, if there's no detail, then it means that you are not contemplated and therefore not deserving of those rights. Somewhat of a paradox, I think, but I do reject that approach of different categories of rights as being not only alienating, but somewhat counterproductive. And this is why I say that our human rights agenda, we need to rethink how we approach it. On the one hand, to broaden it in the sense of making it much more inclusive, but also on the other hand, being able to focus more directly or more restrictively on a simple understanding of rights as delivering basic entitlements to all. So you need not have categories in terms of what it is that we are entitled to. And I take comfort from the preamble sections in our Bills of Rights, which we all have in all our constitutions, which says, whereas every person is entitled to the fundamental rights and freedoms, that is to say, the right to each and all of the following, namely life, liberty, security of the person, equality before the law, and protection of the law. And that phrase for me sums up the essence of human rights, because to me it speaks a very basic notion of the dignity of the individual, the worth of each person in our planet. And I think it contains all the protection that we need in the HIV agenda. So that is the phrase and the clause that I think needs to have judicial currency. And we have seen new cases in the region, new jurisprudence, where we've been attempting to interpret our preamble, which I just read to you from, in more liberal ways. And that can only serve us well in the HIV agenda. So a more dynamic interpretation of our human rights bills and our constitutions, more elemental rights. And in a strange way, I think actually what we've been doing in terms of these various categories of rights, whether it be for women, whether it be for vulnerable groups, as the case may be, in some ways I think it's even divisive, in the sense that we have moved away from this universal application of equality, liberty, protection, and so on. So, and also in some way marginalizing the issues in relation to HIV. So we're back to us and them. So we need to lobby for specific rights, as opposed to a point of view that certain basic rights are deserving to all. And I was listening to the end of the last discussion when I came in the group before us. And I thought it was very interesting when the last point that was being made was that in the fight to reverse the sodomy laws in Jamaica and elsewhere in the region, the speaker was saying, and he's involved in it, that they have recognized that it's not enough. It's not enough to do that in order to get rights or to prevent discrimination. And it certainly emphasizes the point I'm trying to make, that instead of making it into about categories of rights and what is listed in the Constitution and so on, that we need to have a much more expansive concept, a more universal principle. So I am interested in developing a culture of human rights, a culture which sees the deserving beneficiaries of human rights as simply being humans, persons. We are all deserving. And the starting point is simply the premise that all persons suffer from stigma, regardless of how or why the reasons for that stigma. I think also in our construct of human rights, we have to be able to go beyond the territorial jurisdiction point and the boundaries, our borders, given that we have in the region not just the free movement issue, but we also have important issues in relation to asylum seekers, whether they be from Haiti or whether they be from outside of the region, where our own nationals now are seeking asylum, UK, etc. So I think our human rights construct has to be able to embrace those issues across borders. I was told that our time is cut down, so I know I'm coming close to it, am I? So I'm going to skip out a bit of that. But simply to say that this is a very important topic right now. Just recently in Barbados, the health benefits system was rearranged so that persons who are not nationals are no longer entitled to health benefits, even though they've been paying their taxes, etc. And my point is, in relation to HIV, that we have to be able to reach beyond borders and embrace certain human rights principles in relation to migrants and non-nationals. For instance, on the basis of the right to life. And the right to life has been interpreted, and again, exciting prospect, in India, for example, as being able to encompass the right to health. So although the right to health is not mentioned, the right to life is broad enough to encompass those kinds of issues. So that you need to be able to expand these concepts of rights to include these kinds of issues, economic and social rights, cultural rights, your right to health, particularly in relation to non-nationals, whether or not they are paying taxes. There's a general principle of being at risk because of health issues, and also the principle of possible harm or risk in relation to HIV itself. So that even in terms of the cost argument, the argument of your public purse, universal principles of human rights should be able to extend to reach out on the basis to your right to life, your right to quality of life, your right to health, and being provided with a minimum standard of care. We noticed that elsewhere in the UK and the USA, we've seen where these principles, the rights to life and how that affects HIV, these principles have been accepted by the courts in relation to persons who went to these countries from Africa, from the Caribbean, claiming, for instance, that their very lives were threatened because they did not have adequate access to health care. Of course, that is changing, but even if you have health care in your country and you're discriminated against and you're not able to access it, there's still an issue with health care. And they have been successfully lobbied, the UK courts, for instance, and claimed asylum on human rights grounds on the basis of their rights to life and humanitarian grounds. Similarly, we've seen such cases in relation to non-nationals from the region, St. Kitts, Jamaica, etc., where they've also been able to claim asylum on the basis of discrimination on account of their sexual orientation. So we are beginning to see that courts outside of the region are recognizing these broad rights and accepting that it was sufficient to be able to demonstrate that your life, it was enough to demonstrate that your life was being threatened, and that was sufficient to invoke human rights principles. And that's the direction I think we need to be going. Clearly, this is not going to happen overnight, and certainly what we need in order to rethink our rights issues, our constitutional issues, is to have efficient litigation strategies. Again, I see some exciting prospects. We have a case in Jamaica about to go to the Inter-American Human Rights Commission. We have a case in Belize on sodomy laws, etc., in the context of HIV. And I think these are the kinds of challenges, these are the kinds of litigation strategies that will indeed challenge how we view our bills of rights, our constitutions. And that, I think, will in itself cause behavioral change. I also believe that apart from the strict bills of rights and constitutional law discussions, that as a supplementary tool and as a pragmatic approach, a practical approach to reaching rights in the populist sense, meaning entitlements, we need to have broad-based ordinary legislation, like anti-discrimination legislation, for instance, which would supplement these more fundamental norms that we can and should identify in a constitution. And so that is particularly important because of the fact that our constitutions, even if they were liberally interpreted, cannot extend to the private sphere, because really we're just talking about the actions of the state and not, so you couldn't talk about employers, for example, in terms of human rights violations. So that really and truly we are moving towards, in very small steps I would imagine, we are moving towards a more generous interpretation of our constitutions and bills of rights, but there are still many obstacles. The final point I want to make, and hopefully our discussion will give us room to flesh out some more issues. The final point I want to make is about how we go about balancing these rights, because often we have too easily permitted so-called rights to succumb to broader public interests, which when we rethink these public interests are no longer so relevant. So for example, your right to privacy as against the right to know, your rights in relation to treatment and even again migration as against harm to the public and risk to the public because of HIV, when today we know that there's very little risk in terms of medical risk, that is. And so there's no need for those kinds of rights to be always so vulnerable to the competing interests of the society. So then, several challenges in relation to the human rights agenda, but at the same time, some prospects which I think are important on the horizon, and the task is to be able to put forward a broad equality agenda, a broad equality and rights agenda, which would liberate rather than cement some of these underlying prejudices in the society and move towards basic principles of fairness, dignity, and equity. Thank you.
Thank you, Rosemary, for the thought-provoking delivery, and I am sure we will be having some queries or concerns coming your way at the end of the presentations. We will now move on, and I'm going to ask all of you to hold your questions till the end of these sessions when you can direct your questions to the panelists. I would like to now introduce our second presenter, Mr. Oscar Valdez Guillen, who will present in Spanish. So for those of you, please prepare your earplugs if you need to do so. Oscar Valdez is a well-known, prestigious Dominican professional with over 10 years of experience in the area of rights of people who live with HIV/AIDS, focusing in the education, advocacy, and promoting community participation, and a defender of those populations. In 2002, Mr. Valdez was appointed chief of the Dominican Network of People Living with HIV, Red Dominicano VIH, responsible for planning, implementation, national and international projects. In 2004, Mr. Valdez was the lawyer of the Legal Assistance Program, PAL, with the financial support of World Bank. Mr. Valdez was Human Rights Workshop facilitator both at a national and international level as well. In 2007, he was the Human Rights Manager at the NGO AIDS Coalition. In 2009, Mr. Valdez was the coordinator of the Incidence Public Policy Project in Red VIH with the support of Global Fund Against AIDS, Tuberculosis, and Malaria. Please help me welcome Mr. Oscar Valdez Guillen.
Buenas noches, esperando que estén disfrutando de esta conferencia. Mi tema tiene que ver con la experiencia de la República Dominicana en lo relativo a la legislación sobre la protección de los derechos de las personas que viven con VIH en la República Dominicana. Quiero iniciar con estas palabras de Ferdinand Lassalle, cuando decía que cuando una constitución no se parece a la realidad de su pueblo, es un pedazo de papel. Digo esto porque hablar de una legislación sobre VIH en la República Dominicana era una especie de visibilización de una problemática o de una realidad que existe en esa población. Digo esto porque la Constitución de la República Dominicana desde el año 1844 contempla un catálogo de derechos por el simple hecho de la condición de ser humano. Pero tenemos una cultura en la República Dominicana, producto de la tradición de la legislación francesa, y es que somos muy apegados a la ley. A pesar de que la jerarquía de la norma es la Constitución, hay una concepción en la práctica jurídica que lo que no está en la ley, pues no existe. Ese era el preámbulo con el que quería comenzar. Voy a comenzar a contarle a ustedes la experiencia que ha tenido la República Dominicana en la lucha por una legislación a favor de las personas que viven con VIH. A principios de los años 90, con el boom que hubo a nivel mundial sobre la implementación de políticas sobre la protección de los derechos humanos a favor de las personas que viven con VIH, sobre todo a partir de esa declaración de la Organización Mundial de la Salud del año 1988, donde se ordenaba a todos los países a no aislar a las personas que viven con VIH por entender de que no representaban ningún tipo de peligrosidad para la infección de VIH. A partir de esto se inicia un movimiento donde la sociedad civil de la República Dominicana que trabajaba los temas de VIH se empoderó e incidió a nivel estatal para obtener una ley. Es así como surge la ley 55-93 sobre SIDA. Ya está modificada, pero quiero contarle el proceso. Esta ley, como bien les decía, fue el resultado del aporte satisfactorio del trabajo conjunto entre la sociedad civil y el Estado dominicano. En lo que se puede señalar, entre los temas más relevantes de dicha legislación, se consagró la prohibición de la realización de pruebas obligatorias. Sin embargo, a pesar de nosotros tener una legislación que prohíbe la realización de pruebas de VIH para fines laborales, para fines de atención médica, nos encontramos que es un instrumento que es ineficaz. De ahí vuelvo a tomar la palabra de Ferdinand Lassalle, de que cuando una constitución no se parece a lo que es su pueblo, es un pedazo de papel. Es decir, la queja que tiene el sistema es que las normas no son eficaces. No basta con que tengamos una protección en el marco legislativo. De nada nos sirve si esta no va a ser eficaz. Sin embargo, la República Dominicana se pudo dar el lujo en Latinoamérica y sobre todo en el Caribe de contar con una ley que garantizara y protegiera los derechos. Vuelvo y repito, la ley solamente en la letra. La atención médica, todavía, a pesar de la ley 55-93, en muchas clínicas y hospitales se realizan pruebas de VIH, las solicitan para dar una atención médica. Y en hospitales públicos, el sistema de atención médica en la República Dominicana es público y privado. Recuerdo la experiencia de una miembro de la red de personas que viven con VIH, que hace 2 años se le negó una cirugía, a pesar de tener una ley desde el año 1993, y tuvieron las redes que hacer una incidencia a nivel de los medios de comunicación, hacer una especie de huelga, de reclamo ante el hospital para que pudieran operar la persona de la pierna. Gracias a Dios y producto de la intervención del Consejo Presidencial de SIDA, que es el órgano del Estado que dirige la política de VIH-Sida, más la lucha y la incidencia de la población que vive con VIH en República Dominicana, se pudo obtener esto. Vuelvo y repito, a pesar de tener una ley que protege los derechos de las personas que viven con VIH desde el año 1993 en la República Dominicana. Otro aspecto relevante que tiene esta misma ley 55-93 es que no se le puede negar la atención a la salud a las personas que viven con VIH ni para obtener un empleo. Esta misma ley consagra que las personas que viven con VIH habla de la penalización de la transmisión del VIH. La ley 55-93 estableció un mecanismo que las personas que es VIH positiva al momento de tener una relación sexual con una persona debe de informarle, y si éste no le informa conforme la legislación anterior que teníamos, la 55-93, esta podía ser condenada de 20 a 30 años de reclusión mayor por intento de homicidio. Entonces, hoy día, a pesar de que se está luchando en Latinoamérica por la despenalización de este tipo de práctica, con la ley nueva, que un poquito más adelante le voy a hablar, la ley 135-11, Esa pena de 20 a 30 años se disminuyó de 2 a 5 años cuando la persona que vive con VIH no le informa a su contacto sexual su condición de salud. En el año 2011, producto de que el Estado de la República Dominicana firmó la Asamblea Extraordinaria de las Naciones Unidas, por sus siglas UNGAS, la Declaración de Compromiso sobre el VIH y SIDA y los Derechos Humanos, donde declaró el Estado Dominicano que se comprometía a velar porque las organizaciones de la sociedad civil puedan realizar sus actividades, analizar y reformar leyes discriminatorias y sobre todo garantizar todos los derechos fundamentales a las personas que viven con VIH-Sida. La sociedad civil tomó esa declaración como suya, la difundió, la utilizó y comenzó a exigirle al Estado Dominicano que cumpliera con esa declaración de compromiso que firmó en la Asamblea de Naciones Unidas en el 2001 del UNGAS. Es así como el Consejo Presidencial del SIDA de ese entonces inicia un proceso, estoy hablando en el año 2002, inicia un proceso de reforma a la ley, donde contó con la participación de varios actores. Pero el proceso que se llevó a la fecha no tuvo conformidad con la sociedad civil, o sea, no lo aceptamos como sociedad civil debido a que, o sea, no estábamos de acuerdo con lo que establecía. En el momento de validar el producto final del documento de la ley, cuando se convocó a todos los actores de la sociedad civil, dijimos que no estábamos de acuerdo. De ahí la sociedad civil, a través de la coalición de organización de la sociedad civil, NGO Coalition, que es la entidad que agrupa a todas las organizaciones que trabajan en la temática de VIH en la República Dominicana, decide por sí solo elaborar un anteproyecto de ley. Comenzó este proyecto, esta actividad fue financiada por la USAID y por UNICEF, Naciones Unidas, dieron un apoyo muy importante a la sociedad civil para obtener un producto que era el que la sociedad civil entendía como ideal y que mejor representación le daba y mejor garantía a la protección de los derechos de las personas que viven con VIH. Posteriormente hubo un cambio de gobierno y en el 2004, me parece, si no me equivoco con la fecha, donde estábamos entonces con dos documentos, dos anteproyectos de ley. La sociedad civil tenía un proyecto de ley y el Estado tenía un proyecto de ley. La sociedad civil, por un lado, estaba incidiendo en el Congreso, haciendo lobby, sensibilizando a los senadores y diputados para lograr obtener el apoyo para que primero un legislador se empoderara, porque en ese momento no existía en la República Dominicana la iniciativa legislativa popular. Hoy día, a partir de la reforma constitucional del 2010, existe la iniciativa legislativa popular. Entonces teníamos que hacer el lobby y el cabildeo para que un legislador o un senador se adueñara de ese anteproyecto que había elaborado la sociedad civil para introducirlo. Con el cambio de gobierno en el 2004 hubo una voluntad política ante estos dos documentos, dos anteproyectos de ley con un mismo fin, que era la protección de los derechos de las personas que viven con VIH. Surge entonces una comisión bipartita. Esa comisión bipartita, sociedad civil, Estado Dominicano. Fue un trabajo de casi 8 años de ardua labor, poniéndonos de acuerdo. Nos jalábamos los moños, discusiones, pero se dio durante todo un proceso de negociación, cediendo cosas, ganando cosas, hasta que en el 2011 obtuvimos la ley 135-11. Ahora bien, en cuanto a las buenas prácticas, ¿cuáles son las cosas positivas que tenemos? es que la sociedad civil logró articular con el Estado dominicano la voluntad política para la reforma legislativa. Ahora bien, ¿por qué si desde el año 1993 teníamos una ley, necesitábamos desde el 2002 estamos luchando por transformarla? El problema es que la legislación del año 93 no establecía la realidad, no estaba acorde a la realidad que estaba viviendo el VIH. Digo la realidad en cuanto a los medicamentos antirretrovirales. En el año 1993, en la República Dominicana, no se hablaba de antirretrovirales en el sector salud. La República Dominicana sufrió una transformación en su sistema de seguridad social, donde la salud pasaba de una salud pública pasaba al sistema. Entonces había que reglamentar todo esto. Los medicamentos antirretrovirales y la atención integral en la República Dominicana todavía hasta el momento se suministra a través de donaciones y préstamos. Entonces preguntan los agentes donantes, ¿y cuál es la sostenibilidad que van a ustedes a presentar en el proyecto? Entonces esta ley, lo positivo que trae, la 135-11, que fue aprobada apenas el 9 de junio de este año 2011, esa problemática de la atención, o sea, la responsabilidad del suministro de los medicamentos antirretrovirales, del monitoreo, de la evaluación de las enfermedades oportunistas, pasa al sistema de seguridad social. Los aspectos relevantes de esta ley es que toma gran importancia lo relativo a la equidad de género. En materia de derechos sexuales y reproductivos damos un avance muy importante. Esta ley prevé que las personas que viven con VIH tienen derecho a una salud sexual, y reproductiva. En lo relativo a la salud reproductiva, tuvimos casos en la República Dominicana donde mujeres al dar a luz en los hospitales fueron esterilizadas por los médicos sin su consentimiento. Sé de casos de muchachas que pertenecen a la red de personas que viven con VIH que todavía estaba buscando algún archivo médico que diga que fue cortada las trompas para esterilizarla y no sabe. Entonces, creo que esta ley es un avance. Ahora bien, no basta con que la ley consagre esos derechos. Tengo que irme a la eficacia. La burocracia del sistema judicial no permite que personas de escasos recursos accedan. Sabemos que, como decía alguien por ahí que se me olvidó, que la justicia es un animal que extiende sus garras hasta los pies descalzos. Es decir, la burocracia, cuando una persona va a poner una querella a un juzgado, a un tribunal, a donde un procurador fiscal, se topa con la burocracia de que venga en una semana, en 10 días, hay que notificarla. La justicia no es gratuita, o sea, los jueces no te cobran, pero el procedimiento no es gratis, hay que pagarlo. No contamos, a pesar de que en la declaración de Ungas el Estado se comprometió a dar asistencia legal gratuita, a pesar de que la ley 135-11, la ley vigente que tenemos en su artículo 4, dentro del marco del derecho a la atención integral, establece asistencia legal y psicológica. No contamos con ese instrumento. Y digo esto porque, escuchando la experiencia de la compañera que me antecedió con relación a otros países de Latinoamérica, contamos hoy día con una constitución que nos ayuda a reforzar esa ley, una constitución donde dice y se consagra en su artículo 7 que dice que la República Dominicana es un Estado social y democrático de derecho, donde su principal función es la protección efectiva de los derechos fundamentales. Y no es por casualidad que habla de Estado democrático social de derecho, es que un Estado social de derecho es aquel estado donde a sus ciudadanos, vivan o no vivan con VIH, sino por el simple hecho de ser persona, hay que satisfacerle las necesidades básicas esenciales, como son salud, educación, vivienda, seguridad social, sin ningún tipo de discriminación, ni nada que vulnere o atente contra la dignidad de esta persona. Es decir, entonces, que esta ley 135 se pone acorde con la Constitución vigente. Hoy día se está conformando en la República Dominicana, en mi viaje aquí todavía se está dando el proceso público de selección del Tribunal Constitucional. También se está dando el proceso de elección del Ombudsman o Defensor del Pueblo. Yo tengo fe de que con estos instrumentos jurídicos escritos que tenemos, que garantizan y protegen los derechos, más las instituciones políticas y jurídicas del Estado que se están conformando en la actualidad en la República Dominicana, estamos dando avances agigantados y avance acorde a la protección efectiva de los derechos. Ahora bien, lo que cabe la interrogante, ¿serán real y efectivamente eficaces esos derechos? Tenemos que esperar, porque el Estado hoy día está en una situación que tiene que, en materia de asistencia legal gratuita para la población que vive con VIH en República Dominicana, no tenemos ningún programa hoy día. Vamos a ver qué pasa dentro de pronto. Las pruebas de VIH en los trabajos, en las empresas, se siguen haciendo sin el consentimiento de la persona, a pesar de tener una ley vigente. Yo creo que una de las debilidades, que a pesar de que la ley fue promulgada en junio, que es muy reciente, necesita difundirse. Muchas personas todavía no conocen que tenemos una ley. Y entra una interrogante. Muchas personas preguntan, ¿por qué una ley para personas que viven con VIH? Es que son personas privilegiadas. Y mi derecho a yo contratar a quien yo quiera, ¿dónde están? ¿Dónde están mis derechos humanos? Que ahí entra la discusión de cuáles son los derechos de quién y cuáles son los derechos de aquel. La respuesta siempre es que existe una ley especial para personas que viven con VIH porque tenemos un problema especial que hay que visibilizarlo. Y si no se visibiliza, nadie se va a dar cuenta de lo que está ocurriendo, de la cantidad de derechos que se le violentan a esta población por el simple hecho de vivir con VIH. Ya para finalizar, como recomendación nos queda solamente difundir la ley. Hay que promoverla para que ésta pueda, hay que sensibilizar a toda la estructura estatal, los jueces, los fiscales, que son los que muchas veces se resisten a la aplicación de la norma. Tenemos que sensibilizar a los demás sectores de la sociedad civil y recordarles, ya para finalizar, que si la población no ejerce sus derechos, estas leyes pueden convertirse en inoperables. Gracias.
Thank you, Oscar, for the in-depth delivery of the challenges and situation related to the legislation as it relates to HIV and AIDS and the human rights agenda in the Dominican Republic and by extension the Spanish-speaking Caribbean. We will continue with our third presenter, who I will now introduce. Dr. Ernest Massiah is the director of the UNAIDS Caribbean Regional Support Team, based in Port of Spain, Trinidad. He started his career in the late 1980s at the CARICOM Secretariat. His involvement with HIV started with the first global program on AIDS, GPA, in the Caribbean. In 2006, he served as Special Advisor to the CARICOM, Pan-Caribbean Partnership Against HIV/AIDS, PANCAP, to help coordinate its regional AIDS programs. Dr. Massiah worked for 5 years as the health specialist at the World Bank on the HIV/AIDS and population projects in West Africa and Latin America. He was involved in the development of some of the bank's first regional AIDS strategies. He worked for over 10 years with the Inter-American Development Bank IADV in Washington, where he served as the lead advisor on HIV/AIDS and disability. He has worked extensively in Latin America and the Caribbean. Prior to joining UNAIDS in 2010, Dr. Massiah was the head of the health section at the Commonwealth Secretariat in London, leading a health program that covered 4 sub-regions: Caribbean, Africa, Southeast Asia, and the Pacific. He studied at the University of Waterloo in Canada, the London School of Economics, and holds a doctorate in public health from the Johns Hopkins University. Please help me welcome Dr. Ernest Massiah. Thank you.
Good afternoon. How do you fashion a people? That was a question that started about 50 years ago in this region, when governments became independent, when these countries became independent. How do you fashion a people? What was going to be the model for the Caribbean man and woman? In 1844, the same question was asked in the Dominican Republic when it gained its independence from Haiti. Y si quisiera yo poder hablar en español, porque pienso que hay un problema con la traducción. And in 1804, when Haiti gained its independence from France, the question in the 1960s in the English-speaking Caribbean, in the 1970s as the countries became independent, was how do you fashion a people? Who was to be included? And the whole question of visibility became paramount. And that was reflected in the constitutions at the time. But for most people at a layman's level, they don't really know what's in their constitutions. They say sometimes as children every day their national anthems. Here every creed and race find an equal place is one from Trinidad, out of many one people in Jamaica. But the most interesting thing is when you look back at who was supposed to be visible in these constitutions at that point in time, it is who was left out. What was not being considered. And what was not being considered most of the time across this region was the whole question of sex and sexuality and sexual orientation. Those issues were not paramount in the minds of our leaders at the time these countries became independent. And 30 years hence, when we have this epidemic of HIV, the question of visibility has become, ironically, more visible. And it is as we start looking back and looking forward, we see where there needs to be a certain redress in the legal instruments that define who we are as a Caribbean people. From my view, the human rights struggle that we see in HIV/AIDS is not really about just HIV/AIDS. It is fundamentally about who we are as a Caribbean people and how do we go about ensuring the participation of all citizens in the Caribbean in their development, in their growth as a country, and as people being able to respect those rights. That, to me, is what HIV/AIDS has brought to this question of who are we as a people and how do we fashion a people. I'm often asked and told that the questions about human rights are a foreign agenda. I think we have to totally remove that question from our jargon. Human rights are not new. We may have called it something else. As a small child in school, I didn't learn about human rights. I learned about prejudice. I learned all the things that one would use to define someone who was different. And it is that way of being in the Caribbean that we have to confront. Because in terms of who is not visible, it is about people of different sexual orientations. It is about people of different colors and shades. And it is also about people who are poor. And it is the juxtapositioning now of all of those factors that is forcing us, as we look at HIV/AIDS, to see how do we change these legal structures. But it is not a foreign agenda. It is an agenda that is intrinsic to who we are as Caribbean people and the trajectory that we have followed to get to this stage. It is also, too, a public health imperative. It is a public health imperative because the existing legal frameworks that we have, the laws that define who is acceptable and who is not, have an influence on behavior. They have an influence on the behavior of someone who is HIV positive, and they have an influence on the behavior of people who interact with those who are HIV positive. They establish a framework of what is seen as acceptable. And that is where we need to make the changes. We need to have an approach to human rights that redefines fundamentally where this region is going to go forward for HIV/AIDS and where this region goes forward as a region that says all Caribbean citizens are equal and will enjoy the protections of the law as a basic right. But when we speak about the law, it is often in terms of the laws, one of the most egregious laws in terms of the sodomy laws. And I am reminded of part of the justification, the most eloquent piece by the Delhi High Court in why India rejected its sodomy laws. And one of the descriptions towards the end of this 130-page document speaks fundamentally to what was the image, the vision that Nehru had within a new India, a new country. What was the vision for the people? And how that vision, which still exists and is still valid, was incompatible with a law that had its antecedents in 1864 and therefore needed to be amended. The basic change in that law was a human rights agenda, but it was justified, among other things, in terms of how did this reflect what this country was intended to become. And I think the same question is valid for us here in the Caribbean. The other aspect about changing the laws, because you're often told, but if we change the laws, that isn't necessarily going to have an impact on HIV. But the existence of the laws allows for occasions of arbitrary discrimination against Caribbean citizens. And that is perhaps one of the most compelling reasons for why we need to change the legal systems, the laws that prevent Caribbean people from accessing services, from participating in their countries, is that many of the laws that exist allow for arbitrary discrimination. But let me give you a fine example. In many of our countries, sex workers, transgendered people may not be arrested under the sodomy law. But there are laws that exist in our books, simple laws such as loitering laws, that are used to harass people and arrest them. And I witnessed a most amazing case recently in Trinidad, where a group of transgendered persons were arrested for loitering on a Friday afternoon late, which meant that they could be held without bail over the weekend, which meant that that time while they were in prison, they were subject to abuse, which meant that when they were brought to court on a Monday, they were photographed and, in a sense, publicized in the newspapers, and then on a Tuesday they were released. It was a case where an existing law was used to demonstrate the power of the state to harass and persecute someone. But this is not unique to one country. This is unique to the region. This is unique to the world in terms of laws and legislations that exist. But we need to also look at where there are cases of new laws being implemented or attempts to implement new laws. And we've had a case, we've had successful attempts being made to introduce laws that would criminalize HIV. And by successful, I mean that bills entered into their parliaments, and there have been discussions on them. But one of the things that we need to fight against is the notion that HIV is a crime. HIV is a virus. It is not a crime. And so as we look at the human rights issues and the legal issues, we need to be concerned not only with the laws that exist, but the laws that are attempted to be introduced. But there have been two very successful attempts in the region to have these discussions in Parliament, and I have to admit there have been two very successful cases where these laws have not been passed because the legislators have agreed that this would in fact not help the public health imperative of reducing the spread of HIV/AIDS, but in fact do harm to that attempt. But I'd like to look in terms of rights, as has been mentioned by one of the speakers, as to some of the bits of legislation that we do need. And we do need a legislation in countries about anti-discrimination. And there are bits of legislation that have been implemented that speak to anti-discrimination. And those need to be expanded through the region. But there is a bit of legislation in the English-speaking Caribbean that perhaps is lacking. When one looks at the CARICOM framework and the range of legislation and treaties that exist, there's one glaring omission. And that omission is that we do not yet have a human rights charter. We do not have a human rights charter that speaks to the rights of all Caribbean citizens. And that legislation, along with the bits of legislation that speak to economic union, that speak to trade and integration, that speak to agricultural policy, is a missing bit at a regional level that would enshrine in it the rights of Caribbean citizens, not just for HIV/AIDS, but rights in general that would include HIV/AIDS. It would speak to rights of women. It would speak to rights of children. It would speak to rights of the poor and the most vulnerable. It would speak to the rights of those who are not visible and need to be included. That's a missing piece in our legislation as we move forward. But how do we move forward? We have seen a range of initiatives for moving forward. And I think I would like to stress a point made by the first speaker. As we look to the rights that we need to gain for people living with HIV, we have perhaps at times done this in a very vertical and perhaps very insular way. Just the rights of people living with HIV. But a person living with HIV has many other characteristics. They are mothers, they are fathers, they're brothers, they're sisters, they're poor, they're rich, they're various ethnicities, they may even have disabilities. There are many other characteristics. And in making this move forward to ensure that we get the rights of people living with HIV, we need to think a bit more broadly of how do we bring a wider constituency into this discussion about rights. Because it is not just the rights of people living with HIV, perhaps, that we need to be concerned with. We need to think of their other roles. We need to think of the other factors, the other characteristics intrinsic to them that may lead to them being excluded. We need also, too, to ensure that the language we use in trying to educate our Caribbean people about their rights is one that perhaps is devoid of some of the jargon that we so effectively manage and mangle at times. We need to be able to start a process of education, of educating our people of the rights that they have, of the rights that they have lost, and the rights that may be taken away from them. And that is part of a much bigger agenda. That is part of the unfinished work, in at least the English-speaking Caribbean, of the independence movement. We educated our people about the need for independence, of the need to stand independently in the world, to be visible, to express our presence. But we have not continued that education of educating people about their rights, about what it is to be a modern Caribbean citizen. And that process of education needs to continue to involve HIV/AIDS, but also the other aspects of our development that need to be considered. But one of the most pressing needs, I think, as we move forward, has to be, how do we protect those at this point in time who are vulnerable, who are unaware, and who perhaps have had an experience, an intergenerational experience of being ostracized, of being invisible, and of not knowing where to turn to for their rights. And in all of the countries in the Caribbean, we have populations who have that experience, that intergenerational experience of not knowing what their rights are. And we need to be able to protect that population. Tomorrow, with UNAIDS, we shall speak and announce the launch of the Coalition for Social Justice. And one of the objectives of that Coalition for Social Justice is to be able to provide at a regional level a mechanism for redress, a mechanism that allows those who experience arbitrary discrimination, but who do not have the resources, financial, psychological, and what I call basic social support, to be able to speak out, to ensure that they get redress in the system, and most importantly, that these cases of arbitrary discrimination are stopped, because there is a response to this that comes from people and takes them forward. So as we look at human rights and we look at the law, I want to end by saying this is not a new agenda. This is an agenda fundamentally about how do we fashion a people and what are the values that we stand for. And this is an agenda that didn't start with HIV/AIDS. It started long before HIV/AIDS. But this is an agenda that has had to respond to HIV/AIDS, because what HIV/AIDS has shown are the gaps in the thinking at the time. It is speaking to those who were excluded when constitutions were being written. And it is imperative for us to ensure, as we believe in human rights for all, that those who have been excluded are included, and those who have been excluded have the options for redress, because otherwise we are not perhaps going to be the people that we thought we were. We will not be the region that lives up to the words of the national anthems that we ask our children to sing in schools in the morning, some of which say, "Here every creed and race find an equal place." Mottos that say, "Out of many, one people." We may not be living up to our ideals. And that is a tragedy for us as a people. Thank you.
Thank you, Dr. Massiah, for the enlightening and thought-provoking delivery. In essence, we have to see a change in the perceptions of our people and the mindset. And I would also like to thank you for the announcement of the launch of the Social Justice Coalition, an action that I'm sure has been long awaited and welcomed as of tomorrow. I would now like to open the floor to questions from the audience. Please use the microphones for the purposes of translation as well.
Good afternoon. Yvette Delph, now living in the States. I'd like to thank all of the presenters for their perspective, and in particular, Dr. Massiah, for your challenge to us about fashioning a Caribbean people. Many times when we think about human rights, we think too frequently about legislation. And I see legislation as actually the first rung of the ladder. And we still haven't really got to that first rung in which basic human rights for everyone are enshrined, and that there is no discrimination. Beyond that, as you said, we have to educate people about their rights so that they can be empowered and enjoy those rights. So that would be the next rung. And beyond that, we need to reach a point where we are celebrating our differences, where we are enjoying and recognizing the strength of our diversity, and that it is our differences and our diversity as a Caribbean people that actually makes us strong. And until we can reach there, as long as any one individual is discriminated against, each of us is diminished, and the Caribbean as a whole is diminished, and we are not going to reach our full potential. I would like to ask each of you from your perspectives, how can we move ourselves up that ladder? What does it take to get there? Thank you.
Hi, good afternoon, everyone. I am Margarita Elliott from Trinidad and Tobago, and I also represent the Red Cross in the region. And I have no apologies by saying the Red Cross is the greatest organization in the world. And therein lies a lot of contradictions, because as an organization, we value highly our access to a lot of vulnerable populations to be able to act on their behalf. But then there's also another school of thought that says that we sometimes sacrifice rights for access. And that is something that we also have to battle with in the Caribbean, because there are national societies that belong to the Red Cross that do work with vulnerable populations. In Jamaica, Jamaican Red Cross works with MSM. In Guyana, we work with sex workers who service the mining population in the hinterlands. We work with the Haitian migrant population in the Bahamas. We work with MSM in Trinidad. And the list goes on and on and on. So bringing life to law and human rights and the gender issues, sometimes with HIV, it challenges, whilst we have all these structural things that allow some of these things to happen in HIV, it should be acknowledged that HIV is confronting some of those. In the context of providing protection to persons, good legal representation is expensive. And if you can't afford a good lawyer, very often, nothing happens. And are we dependent then on our criminal law to develop what has to take place in the context of HIV? But I'm very thankful that we can have these kinds of discussions. I'm glad to see Oscar. After 10 years, things are happening in the DR, and it's good to see you. So, in going forward, what do we do? I mean, I'm glad that this movement for social justice is happening, and be interested to see what takes place. But we still need to work with the lawmakers. We still need to work with judges. And if we leave them out very often, civil society will just be some people who are talking all the time. Because we have judges who are gay in Trinidad and other parts of the Caribbean. We have parliamentarians who are HIV positive. But what are we doing about it? So it wasn't a question, it's just a comment. Thanks.
Thank you. Erica?
Bueno, buenas tardes. Voy a hablar en español. Soy Erika Suero, subconsultora jurídica del Consejo Nacional para el VIH y el SIDA de la República Dominicana. Lo primero que quiero comentar es que aplaudo la decisión de la conferencia de haber incluido un tema tan importante como este para la respuesta de todos los países a nivel mundial a esta condición de salud. En segundo lugar, hacer un comentario, y es que me gustaría resaltar lo ya dicho por los ponentes, en el sentido de que es muy importante una educación efectiva en derechos humanos a la población en sentido general, en un lenguaje que pueda ser interiorizado por cada una de ellas en su debido nivel, ¿no? Porque una población que no conoce sus derechos evidentemente no puede ejercerlos ni puede exigir su reconocimiento, ¿no? Pero amén de eso también es importante que dentro de esa concienciación ciudadana con respecto a los derechos humanos hay que concientizar con respecto a los deberes. Porque así como uno puede exigir derechos, también uno tiene que cumplir con ciertos parámetros y ciertos deberes. Otro punto importante que quiero destacar es dónde entran aquellos instrumentos jurídicos de derecho internacional suscritos, adoptados y ratificados por muchos países en contraposición o complementariamente a aquellos instrumentos jurídicos nacionales, tales como la Constitución de la República y las leyes especiales, las leyes adjetivas que se derivan de esa Carta Magna y de esa ley de leyes, porque se supone que en principio esos instrumentos deben de ser tomados en cuenta al momento de tu exigir algún derecho o de conocer un caso en particular. Y ya para finalizar, yo diría que nosotros tenemos la responsabilidad de acercarnos a esos grupos de personas que viven con VIH, precisamente para empoderarlos con respecto a la responsabilidad que ellos tienen a su vez con respecto, valga la redundancia, a sus representados, para transferir esa capacidad en sus representados, de poder exigir los derechos y de poder instrumentar favorablemente y de una manera completa cualquier solicitud que se vaya a hacer ante cualquier instancia, porque muchas veces las instancias existen, sin embargo, no hay un acercamiento a la instancia pertinente de la forma adecuada, y si no se acerca uno como debe de ser, pues entonces evidentemente no va a haber una respuesta. Y esto lo estoy diciendo de forma tal que veamos en la situación no solamente desde un lado, sino que la veamos desde una forma general, tomando en cuenta cada actor y todos los aspectos que de ella se desprenden.
Thank you, Erica. In the protection of time here, because we are starting to run out, I would like to give the presenters the time, and if you can do that within a minute, yes, as quick as we can, to respond to the question that is on the table. All right?
That's it, yeah. What does it take? Well, I just want to reiterate one of the things I believe is really important right now, which we are now beginning to see, is effective litigation strategies. I talked about reimagining our constitutions and really challenging our constitutions to stretch the concepts that we have, some of which before we thought they were not enforceable or justiciable. And we are now seeing that the more we challenge them and the more we train our judges, we are beginning to see the kinds of results that we would want to have. I also mentioned ordinary legislation to supplement the Constitution. The Constitution cannot do everything for some of the reasons that I mentioned. And for example, now we are seeing the preamble, what used to be thought the preamble rights, the general rights about equality and so on, are now being given life in our jurisprudence. We are extending some of the concepts such as right to life. And these things can only come about if we have effective litigation strategies. And then your question, Erica, on international law, let me just say that that's a fundamental difference between the Dominican Republic and Latin American countries and our own countries, where international law is... You're not hearing anything? Oh, because he told me to be quick.
The translation, could you please put the volume up on that, because they're not hearing it through the intercom.
Should I repeat? Yes, I was saying, yes, in terms of what does it take. One of the things it would take in my view, is an effective litigation strategy, which we are now beginning to embark on, what I see as a prospect in order to overcome some of the challenges, given that our constitutions are still very exclusive as opposed to being inclusive, which is where we want to go, and to be able to challenge some of these restrictive concepts in our constitutions and our rights instruments, being able to stretch, let's say, the right to life to mean more things, include right to health and so on, as has happened in other countries such as in India, reimagining our constitutions. I talked about also being able, through litigation, to test what the preamble rights mean. I read it to you in my presentation, equality and protection. Those are general declarations which before we thought were only ideals, but as we challenge them in litigation, they can be broad enough to include all groups and categories. And of course, at the same time, educating our judges, as some persons have mentioned, to see it in this way. And in relation to your comment about international law, Erica, to say that that is one of the fundamental differences between our common law system and those in Dominican Republic and civil law jurisdictions where international law is not enforceable in our jurisdictions. And in fact, the charter that Dr. Massiah talked about would not be binding. CARICOM is moving towards a charter. So we really do have to move towards constitutional change, either through constitutional reform, ordinary legislation to supplement it, or reinterpreting our constitutions in more dynamic ways. That's the way.
Sí, con relación a la aplicación de la norma del derecho internacional en el derecho interno en la República Dominicana, tenemos un artículo en la Constitución que establece que los tratados y pactos firmados por la República Dominicana, pues una vez son refrendados por los poderes públicos, estos tienen rango constitucional. También en el artículo 74 de la Constitución Dominicana establece las reglas de interpretación de los derechos fundamentales en cuanto a que cuando colindan dos derechos, o sea, dos derechos están en choque, en juego, el juez debe deliberar, esto ya en materia procesal constitucional, el juez debe aplicar la norma que mejor le favorezca a la persona.
Let me just add to the comments that have been made. I think, yes, moving forward, we definitely need to have the legal frameworks adjusted and made more in keeping with where a Caribbean people want to be and where a Caribbean people should be going. I think that is one aspect of it, a very important aspect of it. There's another aspect of it about educating the people to know their rights and to also to provide the means for them to be able to seek redress when their rights have been infringed. We need to work on 3 levels because having one and not the other 2 is not going to lead to success. We need to have all of those systems in place. Thank you.
Thank you, Dr. Massiah. Because we are out of time and actually a little over already, I do have to wrap up this session and thank all the moderators and the presenters actually for their great contributions in this session. And for those of you that did not get to ask your questions, please try and hook up with the presenters and still get an answer on your question if you so desire. But unfortunately, we do have to wrap up. I would like to wish you all a continued good conference, a productive one that's informative and that you can take home and get lots done. So once again, thank you on behalf of the presenters here and from the conference secretariat. Enjoy the rest of the conference.